Employment Practice at Trilegal. Hi, Mr. Gupta. Thank you so much for joining us this morning. Very good morning. And, firstly, tell us how exactly are these rules going to impact gig workers? How smooth is this transition going to be? And also, any old labor law provisions that are still going to be at play until states notify these rules? So, is there going to be an issue of dual compliance? Could that something be that we're going to look at?
Hi, good morning, Kanesh. Yes, there's certainly going to be a fair bit of complexity and ambiguity in the coming few months because what has been notified are only the central laws and the accompanying state rules that can sometimes, not always, be necessary for the effective implementation of these rules. And these central laws have not yet been enacted by the state governments. So what's going to effectively happen is that all the old laws have been repealed. They have to be complied with the new laws, the IR code, SS code, etc. But they potentially have to be read in conjunction with the old rules under the repealed laws until the time that the state governments can come out with new rules. So the coming few weeks and months, until the time that the rules are actually implemented, which could have to go through a fresh consultative process, is going to create a situation of fair bit of uncertainty for organizations in terms of how do they comply with the letter of the new codes. In connection with your question on gig workers, pending the implementation of the central codes, a lot of state governments like Rajasthan, Bihar, Karnataka, they have taken the initiative to create their own state level welfare legislations for gig workers, right? So there is certainly going to be a potential of dual compliance, which is a problem that a lot of the industry has continued to face because labor law is a concurrent subject in the constitution. So there is now going to be a potential of dual compliance where organizations will need to comply with the state level gig worker rules, as well as and when the welfare schemes under the central codes are enacted, need to comply with those as well. The state rules actually go a little above and beyond what the central codes say in terms of the protections given to gig workers. And the state governments are also creating their own state level welfare boards with contributions that are meant to be made to those. So I am hoping that in the coming few months, there's going to be further clarity emanating from both the central and the state governments, which will help make matters a little bit more clear and straightforward for the industry in terms of how they should comply. But the reality is that the old laws have now been repealed. So if tomorrow you've got an exiting employee and they need to be paid their gratuity, or if you are an industry which is trying to restructure, you will need to take into account the provisions of the new codes.
Morning, Mr. Gupta. This is Shrishti also joining in. So definitely gig workers will be impacted. But along with that, in the new labor codes, we also see that the government is guaranteeing free annual health checkup for 40 plus workers in that age bracket, and along with that 100% health security in some of the people who work in the hazardous sectors. At this point in time, Mr. Gupta, what is your view on the new rules complying with the international standards, and will the government agencies will solely be responsible to get all these mandates into work, or do you believe that the private participation is also something that the government will foresee to get these new laws into force?
So I think the onus really lies on the government to create the subordinate or delegated legislation, as it's known, right, for the operationalization of these rules. As is normally the case in these kinds of significant legislative developments, this is often done through the consultative process. So the industry does have a very active role to play in helping shape up what the ultimate rules look like, right? And what they believe is going to be a well-balanced and thought-out rule structure within which they can operate. Now, not that this hasn't happened. These codes have been in in the making for many years. The text of these codes has been passed many years ago. There have been many dialogues between trade unions, the government, and the industry. But not all the requests or expectations of the industry have necessarily been taken into account, right? So we're going to have to wait to see what the final form of the various rules look like. A lot of it is still in the works. The delegated legislation is not necessarily out yet. So there remains a certain degree of uncertainty as to how these will ultimately operationalize.
Got it. Mr. Gupta, about the point that you were making about restructuring of salaries, just wanted to understand, of course, this is a great move for further formalization of workforce, but the already current formal workforce, any kind of restructuring that we could see for them in their salaries, at the end of this month probably. And of course, the rule is that by the 7th of the next month, the salaries should be in. So do you think the take-home pay is going to be different slightly on the back of these 50% wages rule, gratuity? So the new rules that have come in, could that change the structure of the current salary? Could take-home pay change for the current employees who are in the formal workforce?
So there are a lot of misconceptions, unfortunately, around what the new rules imply, right? One of the common misconceptions is that everyone's basic salary has to change to 50%. That's actually not the case, at least as per my reading of the new definition of wages. What the government is essentially doing is trying to address practices where the basic salary used to be, in many organizations, a very small percentage of the gross income. And then they would calculate certain benefits, either social security contributions or end of service payments, on that smaller component of basic salary. What the government has essentially done in the new definition is to say that if your covered components of wages are less than 50% of the gross, then we will deem the wages on which various benefits have to be calculated to be at least 50%, right? So it's basically a measure to build in a certain degree of certainty and to avoid various exit payments and benefits to be calculated on a very small portion of the gross income, correct? Now, in terms of what this is going to do as an impact on take home, I don't necessarily see any immediate impact, right? Because contributions and deductions on salaries, which are typically for things like Provident Fund, is not changing. The PF code has not yet been repealed, right?
Yeah.
But organizations will also see a potential impact on how they calculate some of these benefits going forward.
Sure.
Gratuity today is calculated on the basic salary. Tomorrow it's on the new definition of wages. So they are going to try and look at restructuring their wages.